All right, good afternoon, everyone. For the sake of time, we're going to get started right on time today just because we have a lot of content to cover and I want to leave plenty of time at the end for any questions that y'all have. So let's go ahead and get started. So just as some housekeeping before we get started, these webinars are intended for educational purposes only. Now, while we hope that you learn new information, the trainers that present these webinars are not attorneys. Therefore, all information provided during the presentation and the Q&A session should not be construed as legal advice. All right, well, with that out of the way, my name is Brianna Grimes. I'm the Senior HR Services Advisor for Pay Entry, and I would like to welcome you to our very first December mini-series 2021 State Law Update webinar dedicated solely to California because California always gives us plenty to talk about at the end of the year. Now, I'm sure you will have a lot of questions, so please feel free to type the questions into the question box as we are going through the presentation. Kathy is also on the webinar with me, and she's going to be kind of monitoring the questions, and if there are any technical difficulties or clarifications, she may be able to answer those for you during that time. If not, at the very end, she will go through those questions for me, and we'll get as many answered as we possibly can. Now, some of your questions may not have immediate answers that I'm able to give you, as these are new or expanded laws that are still subject to legal interpretation in the areas where they are ambiguous. As we all know, laws are always written ambiguously. So we're going to do the best we can to answer any questions that you have, but any questions that we're not able to answer or give you a thorough enough answer, we will research and reach out to you after the webinar. So feel free to ask as many questions as you feel comfortable doing, and we will be sure to get you the answers either at the end today or after the presentation. All right, so with that being said, let's jump into our content. All right, so we have a lot of changes to talk about in California. Today we're going to be talking about the minimum wage increase, COVID-19 and workers' comp, the mandated COVID-19 reporting, paid sick leave designation changes, crime victim leave expansion, the new CFRA in 2021, that's a big one, DLSE complaint times, paid data reporting, child abuse mandated reporters changing, and expansion of paid family leave, and changes in settlement agreements. So lots to talk about today. But first, let's start off with something easy. So let's start off with the minimum wage changing. All right, so beginning on January 1st of 2021, the minimum wage in California will increase to $14 per hour for employers with 26 or more employees based on previous legislation that was signed by Governor Brown in 2015. Now, the minimum wage for employers with 25 or less employees will also be increasing to $13 per hour. Now, keep in mind that many cities have local minimum wages that will also go into effect. So be sure to verify whether or not your city has a higher local minimum wage than the state minimum wage. Now, remember that when minimum wage does go up, so does the threshold for exempt employees. So for employers with more than 26 employees, the annual exempt salary threshold is now $58,240. And for employers with less than 25 employees, the threshold is now $54,080. So what are the action items that you need to take as an employer regarding this change? Well, just be sure to conduct a wage audit to identify any employees that will not be meeting that minimum wage in 2021 and prepare to adjust their wages so their new pay will go into effect January 1st of 2021. All right, so the next few changes we're going to go over have to do with COVID. Some of them went into effect earlier in 2020, but given the ongoing COVID-19 crisis and the impending changes, we're going to review a couple of these with you as well as go over some of the changes in 2021. All right, so Senate Bill 1159 went into effect on September 17th of 2020, and it essentially said that employees can claim workers' compensation for COVID-19 cases that they contracted in the workplace starting any time on or after July 6th of 2020. It also stated that employers have the right to rebut the claim with viable evidence, and those employers have to have 5 or more employees to do so. So let's dive into this a little bit. Now, the main presumptions being made with this law is that the situation will only arise if the employee contracted COVID-19 during an outbreak in the workplace. And more specifically, an employee has to have a positive test and there is an outbreak in the workplace within 14 days of that initial test. Now, this bill goes on to define exactly what constitutes an outbreak in the workplace. It is defined as For employers with more than 100 employees, an outbreak is 4% or more of your workforce contracting the virus. Now, for employers with less than 100 employees, an outbreak is just 4 or more employees contracting the virus. So whether you have 5 employees or whether you have 99 employees, 4 cases is going to define what an outbreak is for you. Now, the main thing to keep in mind here is that the injury is compensable unless the employer can rebut with evidence to support that the outbreak did not occur in the workplace. So how do you rebut, and what kind of evidence do you need to fight these types of workers' comp claims that may possibly not be tied to your workplace? Well, companies must establish and demonstrate that they have robust health and safety measures in place that minimize the risk to all of the employees in their workplace. Now, examples of these types of safety procedures are basically anything that follows the CDC guidelines, state and county guidelines, and this includes adhering to those social distancing practices that we're all very familiar with now, face mask requirements, as well as hygiene education and postings and posters inside of your workplace. In addition, an employer must also furnish evidence of an employee's possible outside exposure to COVID-19. And this one is a little bit more complicated to provide, and it does require a lot of documentation on your part. So for an example, if an employee calls out sick or informs the employer of other possible exposures to COVID-19, these should all be documented in their file in case this must be used as evidence of outside exposure to a workers' comp claim. So documentation in this instance is really going to be your best friend. Now, for example, if an employee took PTO and they had requested off and you know it was for travel or to attend a party or go to a funeral or go home for Christmas or attend a concert, in another state, those may possibly be reasons listed within that time off that can be used as documented evidence against COVID-19 as a compensable injury in the workplace because they could have gotten it elsewhere in these instances that you're aware of. So just kind of keep that in mind, as you're talking to employees or as employees are putting in PTO requests or employees are, kind of giving you information on what their travel plans are and things like that. Because in the event that they do contract COVID and they want to file a workers' comp claim against getting it possibly at work, you want to make sure that that is actually the case and we are providing this benefit to employees who actually contract COVID at work and not people who contract it when they decide to travel and then just happen to come back to work. Now, if that was not complicated enough, employers only have 45 days from the day the claim is filed to gather all the evidence for their rebuttal and submit it to the insurance company. And this time frame is actually reduced to 30 days if your organization is in a healthcare industry or you're considered an emergency responder. So if your employees are healthcare workers or emergency responders, you have 30 days. Now, that may seem like a lot of time, maybe to some, to get all this information together, but when you've got multiple claims possibly happening around a similar time frame, it's a lot of information to gather. It's a lot of research, it's a lot of documentation gathering. So again, doing the documentation as you go and really having all of that reporting stuff ready to go is going to be your best friend in this instance. Now, there's also a notification compliance piece to this that employers must abide by. Employers actually must provide notice within 3 days of a positive COVID-19 test in the workplace to the Workers' Comp Claims Administration. So within this notice, you have to provide the list of employees that worked on site in the last 45 days. So this is something that you guys need to be keeping track of if you are not working remote or if you're not having any employees work from home or anything like that. You need to be keeping track of who is on site, who is in the workplace, who possibly is coming into contact, what conference rooms are being used. That type of thing is going to be very important to track because of this reporting piece to the Workers' Comp Administration. Now, this requirement is going to be in effect through January 1st of 2023. So California is anticipating that we are going to be dealing with COVID-based workers' comp claims until 2023. I hope and pray that that is not the case, and things may change. This is subject to change depending on what happens with the vaccine and the new administration. But as of right now, this will be a compliance requirement through 2023. So be prepared to be doing these reports and having this documentation on hand for the next 2 years. And in addition, there is currently a $10,000 fine per incident for failing to comply with these notice requirements. So the state is taking these very, very seriously. We're not entirely sure to what extent they are enforcing them or how they're going to enforce them. We haven't really seen that as of yet because this is a newer law. But with a $10,000 flat fine, regardless of your employer size or how many incidents, and they're doing it per incident, tells us that they are taking this very, very seriously. And again, this is something that they are going to be expecting for the next 2 years. So definitely something you guys want to start thinking about and implementing as best you can. So what are some action items that you need to do to protect your company and remain compliant so you don't get hit with that $10,000 fine? Well, be sure to continue COVID-19 protocols and be diligent on enforcing them at work. Also, secondly, work on implementing the claims reporting process with the Workers' Comp Claim Insurance Administration to avoid those fines. The DWC has created an FAQ to help employers navigate this Senate bill, and the link is provided at the bottom of this slide for more information. I highly recommend going to their website, reading over the FAQ, and then seeing if any of those questions provide more clarity that is specific to your situation. All right, so next we're going to talk about Assembly Bill 685, which talks about COVID-19 reporting. So this is actually going to go into effect January 1st of 2021. So this is coming up. Essentially, this bill requires employers to notify all employees and all on-site workers, including contractors, of a potential COVID-19 exposure within 1 day, 24 hours of receiving notice of the illness from an employee. I know a lot of companies had already been doing that, and they're going to be continuing that until COVID-19 goes away. But as of now, it had not been mandated. Now it is mandated by law that these notifications need to go out. And there are specifications surrounding the notice that you must provide to your workforce. So if you were already doing this, now you just need to make sure that you are compliant with the requirements that they are now putting in what you need to notify your employees of. So here are the specifications of the notice. So the notice has to be provided in writing, and this does include email communication and text message communication. Now, I'm going to put a caveat on this because if your company just rolled out, a new mass email portal or a new intranet or a new text message system, and it's still fairly new, I would highly, highly recommend not using one of your newer communication methods to communicate this type of notification. I would use your tried and true if everyone has a company email or sending out a paper letter to their home addresses, something that every employee has access to in order to remain compliant. So if you, like I said, if you have a new mass communication that you rolled out or it's still has some kinks in it and not everybody has access to it, I don't recommend using that form of written communication just because there will be a possible issue with you being compliant. So definitely use a form of communication that every one of your employees has access to. Also, you must not include the name of the employee in the company who reported the COVID-19 exposure. I know this kind of seems as a no-brainer, but we have had questions on this and we have had some companies do some big oopsies, which we don't want to happen to you. So just make sure that you are not including the name of the employee who had the COVID-19 exposure. You need to be very vague and ambiguous in the sense of, hey, we've had a COVID-19 case reported inside of XYZ office. You possibly could have come into contact. This is the resources that are available to you. It is recommended that you get tested, that kind of information. So just keep it vague and ambiguous. We don't need to give any type of personal information. Also, you must include the company's response plan in terms of disinfection and safety plans to respond to the possible outbreak. Now, this is something that most of you should probably already have in place because we've been dealing with this for almost a year now, but itemizing the exact safety plan and the disinfecting plan that you have in case of an outbreak is going to be key, and it is required in this notification. And finally, you must also include information on COVID-19 related benefits. This includes FFCRA and things like that, any time off that your company specifically is providing to the employees and things of that nature. Now, one of the questions that we've got with this, and I know Kathy talked about this on a previous webinar, is, we haven't gotten word that FFCRA is continuing into January. Should we still continue offering it as a benefit. And our recommendation is going to be, yes, probably. More than likely, it is going to get extended. However, we don't have confirmation of it. But just to be safe rather than sorry, I would still continue offering the time under the FFCRA plan, because more than likely it is going to be extended. So even though it ends as of December 31st, it is still recommended that you provide that as a resource to employees if you do have a case or an outbreak or anything like that in January. All right, so in addition to communicating the outbreak with your workforce, you must also report an outbreak to the local health department in the jurisdiction of the worksite where it occurred. Now, in order to keep you on your toes as professionals, the state of California has created a different definition of outbreak under this Assembly bill than under the previous Senate bill that we just talked about and their definition of an outbreak. So with regards to what qualifies as a reportable outbreak to local health departments, in order to be compliant with this Assembly Bill 685, an outbreak is actually defined as 3 or more lab-confirmed cases in a 2-week period of employees who do not live in the same household. So in the previous Senate bill that we talked about, it was 4% of your workforce if it's 100 people or more, or 4 employees confirmed cases if you have 100 employees or less, or excuse me, less than 100 employees. This definition is 3 lab confirmed cases, flat 3, in a 2-week period, and the employees cannot live in the same household. So if they're roommates, if they're husband, wife, if they're friends, if they're married, siblings, then they count as one case. So if both siblings live together and they both get COVID, that is one lab confirmed case towards your definition of an outbreak, at least for this definition. So in your report to your local health department, you must include the name, the phone numbers, and the occupations of the employees who contracted COVID-19 per the definition above, as well as the worksite location address and the NAICS industry code as well. Also, serious citations and fines will be issued if companies do not comply with this law as well. So again, this is something they're taking very seriously in terms of reporting it to your local health department, because they are trying to crack down on these COVID-19 cases and tracking them and things like that. All right, so this law also goes into effect this law is also effective until January 1st of 2023. So again, state of California is anticipating we're going to be dealing with this for quite some time. So start prepping and coming up with these processes and these policies internally, and expect for them to be in place for the next 2 years. Obviously, that is subject to change. We hope and pray that this will not go on until 2023, but if it does, that's kind of what the state of California has put the end date on currently. So what should your next steps be with regards to Assembly Bill 685? Well, you're going to want to implement a response plan in advance so you have it prepared. So again, remember with that reporting to your employees, you have to itemize what your plan is. That's something that you can prepare ahead of time. Your response to a COVID-19 case should be the same almost every single time. So work with your executives or your managers or your owners to draft a response plan email. So if you need to use it, you have it ready to go. You just fill in the dates, any specifications for that specific scenario, all the information to update it for that case, and you can hit send and you're good to go. You can also refer to the CDC website as far as guidance on how a company should respond when an employee contracts COVID. If you're one of the companies who has been so fortunate so far that they have not had a COVID case happen within their office, you can always go to the CDC website, and they are constantly updating recommendations on how companies should handle COVID cases, or how they need to proceed, or based on the number of employees you have or the type of workplace or industry that you have. They have recommendations on there. So it's a really, really good resource that I recommend looking at if you need a starting place for creating your response plan. Right. The next thing is to figure out, how you're going to communicate this and how you're going to comply. So you should also prepare a model on your communication strategy in advance. Figure out, are you going to do mass email? Are you going to send out formal letters? Are you going to do a combination of both? Are you going to send an email and send letters out? Remember that the notification has to be provided within 1 day, so 24 hours. So you could always send a mass email and then follow up with a letter in the mail just to be extra sure. Again, it's not required. The only thing that is required is that you do provide the notice to the employees within 24 hours. But you also want to focus on answering questions like, how will we distribute the notices? Who's going to be in charge of tracking and reporting the outbreaks to the local health department? Which languages do I need to provide this notice in? If you have employees that speak another language outside of English, the notice does need to be translated into their native language. So who's going to be in charge of translating them? And making sure the translation is still compliant with what is required and that it is translated correctly. And then just verify that you meet all the requirements for compliance. So having most of these items ready in advance is really going to make it easier for you to comply with this law, especially for those of you who've been watching the news. We're seeing cases constantly go up daily. Certain states are shutting down again or, restricting certain businesses again. So this isn't something that we're on the downslope according to the CDC. So there is a very good chance that something like this could happen. So just being prepared is going to save you guys a lot of time and a lot of rushing around if it does happen to your organization. All right, so next we're going to move on from COVID-19 a little bit, and we're going to talk about paid sick leave. So Assembly Bill 2017 is going to be going into effect January 1st of 2021 as well. And essentially this law states that employees have the right to decide if and when they will use the sick leave benefits. So they can choose to either use kin care or sick leave for their own health-related issues. And remember that half of the employee's accrued sick leave can be used for kin care, or also known as just caring for a sick family member that is eligible. Now, employers are not permitted to designate the type of sick pay used, and employees do have the sole discretion. This kind of seems like a no-brainer, but unfortunately this bill arose out of the fact that kin care was being designated by employers that were just inferring that they wanted to use it, and this caused an issue and created a bill, and it was voted in, and now it's a law. So this basically enforces that that it is the employee's sole discretion on what leave designation they're using, whether it's paid sick leave for themselves or if they are going to use the kin care to care for a family member. Now, as far as action items go for this one, you really just kind of want to glance over your employee handbook and just amend any language in your paid sick leave law. If there's anything specific that does not give employees sole discretion or that has any stipulations on sick leave designation. So if you have something in there that says, if the employee does not designate that they're going to use paid sick leave, we're going to automatically put it under kin care, or it will be automatically assigned at manager's discretion. You're going to want to take those statements out because they are no longer compliant with this law. All right, so next we're going to talk about Assembly Bill 2992, which expands on the crime victim leave. Now, this leave should be offered by any employer with 25 or more employees. And this law goes into effect on January 1st of 2021, and it expands the current crime leave to include those who are victims of any violent crime or whose immediate families are victims of homicide. Also, the definition of victim has also been expanded to include anyone who has been caused caused mental injury and or threat of physical injury and whose immediate family member is deceased as the direct result of a crime. So basically just an expansion on this leave in terms of definitions and exactly what it covers. Also included in this expansion is additional language regarding employers' requirements to prohibit any form of retaliation or discrimination against employees utilizing this leave for the eligible reasons as stated under the leave. So what are your next steps? Well, at this time, you should definitely review your employee handbook and revise the leave section to include this policy. If you have more than 25 if you have 25 employees or more and you did not already have this leave included, or if your company grew over the past year and you hit that 25 employee mark, double check your handbook, make sure that this paid leave or this crime victim leave is in there. And again, if you already had this policy in there, make sure that it is updated to reflect the expansion that will go into effect on January the 1st. In addition, take a look at your anti-discrimination policy, either for this particular leave or if you have a general anti-discrimination and retaliation policy in your handbook, and just go ahead and revise any language in that policy to include protecting victims using the crime victim leave if it's not already in there. And lastly, it is highly, highly encouraged that if you manage your leaves of absence internally, that you provide appropriate training to managers or your internal HR team so the leave is documented and administered correctly using these new qualifiers that they have expanded on this leave. All right, we are making headway. We are hitting about the halfway mark now. And here is the big one that I know a lot of you want to know about because this is probably the biggest law change in 2021 for California, and it's going to affect a lot of employers. So Senate Bill 1383 on the California Family Rights Act. This law goes into effect, again, January 1st, 2021, and it actually repeals the California New Parent Leave Act and the original California Family Rights Act, and it replaces it with a brand new California Family Rights Act. So here are the main changes that are coming in 2021 with this new CFRA. Companies now with 5 or more employees are covered by this act. Previously, it was only 50 employees or more. So now if you have 5 or more employees, you are now obligated to provide CFRA. This new CFRA also eliminates the 75-mile radius requirement for employee eligibility. So if you have employees spread out all over California and you you used to have 50 employees, but they were not within a 75-mile radius of each other, then you were not eligible for CFRA. Now they're getting rid of that 75-mile radius qualifier. So it doesn't matter where your employees are, as long as you have 5 of them in California, this leave is going to now be something that you have to offer. It also expands the family for which this leave can be used, and it adds the care of grandparents, grandchildren, siblings, and registered domestic partners as eligible family members for you to take care of and use this family leave for. It also expands bonding leave, and it will provide 12 weeks to each parent if both of the parents are employed by the same employer. Previously, they were only allowed a total of 12 weeks split between the two of them. Now they are eligible for 12 weeks each. And finally, employers are no longer permitted to refuse reinstatement of key employees as was previously allowed by the CFRA under qualifying circumstances. So those are kind of the main changes to the new CFRA. All right, so in addition, the new CFRA expands the definition of child. So now a child is either a person under the age of 18 years or a person who is 18 years or older if they are unable to care for themselves. So that extra clarification on the definition of child has also been addressed. And also, in order to be eligible for the leave, employees still have to meet that eligibility requirement, including the 12 months of service and 1,250 hours worked for the employer in the previous 12 months. But remember, again, that 75-mile radius requirement has been removed, so that is no longer a qualifier for this leave. Now, under this new CFRA, there's also a great risk that employers will be required to offer 24 weeks of leave in a 12-month period. And the reason being is that if FMLA does not cover some of the reasons that is covered under CFRA, then the new CFRA would be used first, and then the employee could actually use their FMLA time later in the same year. So if FMLA does not cover the reason for the leave, but CFRA does, then they cannot run concurrently. So an employee could theoretically apply for 12 weeks of CFRA, then apply for 12 weeks of FMLA, and have a total of 24 weeks of protected leave in a year. So that's something to keep in mind as you guys are figuring out the systems and the processes for this leave. Keep that in mind, is that is a possibility for them to use the leaves, and it's legal. Now, as far as action items go, employers should definitely update their handbook with the new CFRA language and guidelines that have come out with regards to the administration of this leave. Look out for a new poster that will be required starting January 1st of 2021. If you are working from home and you have switched to e-posters, Pay Entry can help. You can email either myself or Kathy Graham after this presentation to get more information on pricing for our e-poster service that will help any of you who have moved to a completely remote or partially remote workforce and still need to be compliant with those poster requirements. Also, if you administer all of your leaves of absence internally, you will definitely need to amend your internal FMLA and CFRA request forms with the new information and reasons attached to the new CFRA leave. And then finally, be sure to train managers on the leave processes and the paperwork required of the employees, especially if you are an employer that has not had to offer CFRA in the past because you did not meet the qualifications. It is important that you don't wait until you get your first leave request to get all the policies, processes, and paperwork in place. Be proactive and make sure that your managers know how to handle all the situations regarding the leave. They know what to look for when an employee needs to take the leave. They know what questions they can and cannot legally ask. So they're prepared when you get that first request. All right, so the next bill we're going to be talking about is Assembly Bill 1947 that deals with the Division of Labor Standards Enforcement Complaints. Now, this law goes into effect January 1st of 2021, and it extends the deadline for labor commissioner complaints to 1 year after a violation, act of retaliation, or release of employment. This has been increased from the 6-month limitation that was previously in the law. It also authorizes the award of attorney fees to prevailing plaintiffs in whistleblower action claims. So companies cannot recover the fees if they lose the litigation, and employees will get their fees covered by the company if they win. And on this one, there's really no action items. This one is more so just an FYI of the updated law. All right, so let's move on to the Senate Bill 973, which talks about the DFEH pay data reporting requirements. So this law actually goes into effect January 1st as well, and it affects all private employers with 100 employees or more, both inside and outside of California. So that's just a grand total 100 employees, no matter where they are. Employers are required to report the number of employees to the DFEH along with their race, their ethnicity, sex, and wage pay band. This data must also be divided into 10 job categories determined by the DFEH and separated into wage pay bands as well. This will be very similar to the process outlined in the EEO1 instruction booklet that you use to process your EEO1 reporting. Now, the DFEH is still working on developing a sample report, so these requirements are subject to change, and there may be more items required to be submitted. This report can be submitted electronically, and the deadline to report it is March 31st of 2021, and then will be annually reported thereafter every year in March. All right, so for this reporting, in order to determine the data of the workforce that you're going to be reporting on, you can actually choose any pay period between October the 2nd and December 31st from the previous year to compile the names of the employees for the report. As far as action items go on this law, we recommend a few things. Start with conducting a pay equity audit. Kathy and I can help you with this if you need it. Because this law is going into effect this year, we are expecting to see a lot of state-initiated audits in the next 12 months with regards to pay equity. So it will be good to be prepared for those audits and have an internal audit done to see if you would pass the state audit. Also work on your data compilation ahead of time. As I stated earlier, you can start as early as October, and that will make sure that you don't rush the data compilation. It does resemble the federal EEO1 report, so it should be relatively familiar to you with regards to format, but if you do have questions on that reporting structure, it's always good to get started early and then figure out if you need to make adjustments along the way. And then finally, work to improve and systemize your pay structures to make it easier from year to year to compile this data, because as I said, this reporting will be going on for the immediate future. There is no end to this reporting, so it looks like this is going to be an indefinite process. So focus on how you determine your pay for new employees and what affects your increases or merits each year to make sure that you are compliant. All right, so next we're going to briefly discuss Assembly Bill 1693, which makes some minor changes to child abuse mandated reporting. Essentially, this update now includes HR personnel of any business that employs minor children, specifically teenagers, and any adults that supervise minor employees. So these two categories of management or members of the company are now legally obligated to report reasonable suspicion of child abuse or neglect for any employee under the age of 18. As far as action items go, if you are an employer who falls into the category, you should update your policy and handbook to provide information on the mandates, as well as provide training for the mandated reporting positions that are now included in this law. All right, so next we're going to review Assembly Bill 2399, which is an expansion of the paid family leave that we talked about a little bit earlier. So this law goes into effect January 1st of 2021 as well, and it does include a new military assist claim. This encompasses time off for participation in a qualifying exigency related to active duty or a call to active duty of either an employee, an employee's spouse, a domestic partner, a child, or a parent in the U.S. Armed Forces. It will also revise defined terms for the paid family leave purpose and includes a specific definition of what a military member is. As far as action items go, you can update your handbook if you are required to offer paid family leave. However, this update is not required and it's more informational for the employees, but it is not a mandated update to your employee handbook. And you can also visit the EDD website as of January 1st of 2021 to download the new paid family leave claim forms if you provide those to your employees. Again, that is a courtesy. You're not required to provide those forms. If the employees are still needing the form, they can go online themselves and file the claim either electronically or print out the forms on the SDI online. All right, so we have reached the last law update, and the last one we're going to look at for 2021 is going to be Assembly Bill 2143, which deals with settlement agreements. So this law goes into effect January 1st of 2021 as well. And the current law states that a no hire provision in a settlement agreement is restricted except where an employee engaged in sexual harassment or assault. Now, this provision is disallowed if the employee filed a claim against the employer, regardless of the conduct that they elicited. Now, the new law expands the actions engaged by the employee to include misconduct or any criminal act, as well as sexual harassment and assault. In addition, the act must be documented by the employer before the employee filed the claim, which would then restrict them from the settlement agreement. For this particular law, again, there are no action items. This law was more of an FYI. All right, I know that was an exorbitant amount of information to process. California always gives us plenty to talk about every year with new laws going into effect. Take a second right now and go ahead and type any questions that you have into the question box. Again, we're going to try to answer them the best we can. Remember, these are new laws, so there may not be any legal guidance on questions that come up yet, but we will do our best to give you as much information as we can. If the question is super specific or I need to look something up in order to clarify, I will definitely reach out to you after the presentation and make sure you get it answered. Also, just as a reminder, this presentation was recorded and it will be available to watch again. So to do that, you can visit www.payentry.com and hover your mouse over the webinars tab at the top and click on webinar recordings. The most recent recordings will be on top, and these are usually posted within 24 hours of the live webinar. You will also receive an emailed copy of the webinar recording tomorrow afternoon. And for those of you who cannot write as fast as I can speak, there is a handout attached to the GoToWebinar of all of the slides that I just went over. So feel free to click on that attachment, save it, print it, and use it as reference because it is chock full of good information. All right, so Kathy, do we have any questions?
We have a couple. We had a couple about I can't type as fast as you talk, so I referred them to the handout that was available, as you just mentioned. And there was one question: do these laws apply to a New Jersey corporation with California employees that live and work in California?
If you have, I'm assuming you're referring to the CFRA or all the laws?
All the laws.
Okay. I know for CFRA specifically, the 5 employee count is 5 employees in California. The other laws, I'm not entirely certain. They didn't specify, so let me look into each of the laws and I will send you an email and find out if there is any differentiation between employees in and out of the state.
Okay, I would imagine that the majority of the laws would apply to someone who has any employees, but the paid family leave is pretty specific. And here's another question about that. When a law specifies the number of employees, is that within California? So I think what we'll do is follow up with an email to everyone and let them know which laws require you to do that if you have out-of-state employees. We have
Yeah,
to look
I'll
at that
definitely check
too,
on that.
because we have California employees. Are there any special provisions for nonprofit organizations?
I didn't see that there was any specifications for nonprofits in the legal updates that were provided. I know there are certain laws, and like for example, I don't think CFRA, but I know for the paid sick leave, I think there are exemptions that you can apply for. I don't know exactly what they qualify as. So let me look into it and see if nonprofit organizations do have any special exemptions that they can apply for. I'm assuming you're probably talking about the CFRA update and the paid sick leave updates. So let me
We
look
could put,
into those
yeah,
and find out if there are any nonprofit exemptions.
okay. And we'll put that in the email.
Yeah.
Because California has a tendency not to be consistent across their laws. It would be nice that if the powers that be would look at something and said, well, it's in this law this way, it needs to be that way in this law. And that's just not the way they write their laws. They're all over the board. So we'll
Yeah,
try.
they like their ambiguity. It's a lot of fun.
Yes, yes. And they like the lawsuits. So
Yeah.
very litigious state. I don't think there are any other questions.
Awesome. Well, thank you guys for your questions today. And we appreciate your time today. Like I said, I know that was a lot of information, but I do hope that you learned great information, new information, took home some nuggets that are going to be useful to your employers. If you still have any questions, please feel free to send me an email. It's listed at the bottom of this slide. Also, we will see you again later this week. If you have not already done so, feel free to register. We're going to be talking about what an EAP program is and how you can implement one with your employer. So if that's something of interest to you, feel free to register for our webinar on Thursday. And then if you do have employees in other states, next week we're going to be covering all of the 2021 state updates for Arizona, Colorado, New Mexico, Utah, and Washington. So be sure to register for that webinar. We have other states coming up as well every Tuesday in December. So be sure to check our webinars page if you have multiple states that you function in. We want to make sure that you are updated on all fronts. But thank you guys so much for your time. We look forward to seeing you at our future webinars. You guys have a great rest of your day.